Does the statute that enables a spouse not to testify against his or her spouse carry over into divorce if the alleged crime took place during the marriage? Now, I don't know the rules as they apply in different jurisdictions, but I can tell you what the rule is in Utah, where I practice divorce and family law. In Utah, the spousal privilege rule is found in Utah Rules of Evidence 502. Rule 502 provides, quote, "An individual has a privilege during the person's life to refuse to testify or to prevent his or her spouse or former spouse from testifying as to any confidential communication made by the individual to the spouse during their marriage, and to prevent another person from disclosing any such confidential communication. The privilege may be claimed by the person who made the confidential communication, the person's guardian or conservator, the non-communicating spouse to whom the confidential communication was made may also claim the privilege on behalf of the person who made the confidential communication during the life of the communicating spouse." There are exceptions to this privilege. Spousal privilege does not exist in the following circumstances. 1. In a civil proceeding in which the spouses are adverse parties. 2. As to any communication which was made, in whole or in part, to enable or aid anyone to commit, to plan to commit, or to conceal a crime or a tort. In a proceeding in which one spouse is charged with a crime or a tort against the person or property of the other spouse, the child of either spouse, a person residing in the household of either spouse, or a third person if the crime or tort is committed in the course of committing a crime or tort against any of the persons named above. And finally, if the interest of a minor child of either spouse may be adversely affected, the court may refuse to allow invocation of the privilege. You can learn more about the spousal privilege by reading Rule 502, and I have provided a link to that rule in the description section of this video.